Welcome to the Thrive podcast with the Shiloh Missionary Baptist Church.
How does your faith kind of play into it, or does it play into it?
What can be done about it? When I say the church, I'm talking about evangelical white Christians and the black folk who attend their churches.
Hello, welcome to the Thrive podcast with the Shiloh Missionary Baptist Church. I'm Fred Jeff Smith, pastor of Shiloh, and I appreciate your taking the time to either view this on YouTube or Facebook or listen to us on Spotify or on iTunes. We're so very grateful whenever we have the opportunity to come into your homes, into your offices, into your automobiles, and we always want to invite you to give us your feedback. You can reach out to me at fredjeffsmith@gmail.com, fredjeffsmith@gmail.com. We always appreciate your comments. I'm very happy today to welcome Judge Don Johnson to the Thrive podcast. Judge, thank you so much for taking the time to come and share with us.
It is more my pleasure than yours.
Well, it's very kind of you. Tell me something. You are a candidate for the Court of Appeals. And I just want to start there.
Okay.
I was with you the other day, and you gave what I thought was a very interesting background to the whole structure of the Court of Appeals here in Louisiana. Could you share that with our audience? Tell us how that came about and what you and your brother, Ron Johnson, who's also a judge here in Baton Rouge, for those who might not know, what you and your brother did to help make the system the way that it is right now.
The idea of moving lawyers to the bench was challenging for blacks here in this parish for most of the time of my life. And around 1980, Ernest Johnson and a group of three other lawyers got together, and Judge Janice Clark was one of those lawyers, and they decided to file a lawsuit under the Voting Rights Act of 1965. And basically the Voting Rights Act said that if you had a concentration of minorities, a concentration of a group of blacks in your parish and county, and those minorities did not have an equal opportunity to get elected as judges, and the equal opportunity was based upon the fact that people voted on racial identification. So with that being a fact, a minority would always be generally voted out because of the fact that the majority race represented and voted the majority. So when that was proven and was litigated all the way to the United States Supreme Court, the judicial system had to redraw or permit blacks to get elected because we had proven that the system was racially biased. So how do you remedy that? At that time, the 19th JDC, where I sit, the 19th Judicial District Court, was elected parish-wide, and it was by majority vote. So the 19th Judicial District settlement that we entered into after we won litigation divided the parish into 3 districts. Now that's on the court where I sit now, the 19th.
Yes, sir.
And in each of those districts, a certain number of seats on the bench were assigned. And we knew what the probable outcome would be because the district lines were drawn with a majority-minority population or a majority-majority population. And then the allocation of the seats were given out. Well, that's the same thing that happened on the First Circuit.
Right.
Now, the First Circuit sits over the trial court, the 19th, many other courts too in our parish, in our area. But nonetheless, we had to also decide how to elect a minority to the First Circuit. Now, we had 4 seats that were elected from Baton Rouge, East Baton Rouge Parish. So the idea was to take basically the area where this church sits away from the river and carve out an inner city district which basically runs from LSU campus to the Baker line, and then it goes out here toward Airline Highway.
Okay.
So we allocated one minority to that seat. And we allocated 3 seats to the other area in the parish, all of the other areas.
This was based on the census, correct?
Exactly.
All right.
The 1980 census.
The 1980 census.
So
Okay.
the 1980 census indicated that the population of our parish demographically was about a third black and 2/3 white. So we allocated seats basically to mimic that ratio.
Okay.
1 seat for the minority, which Judge John Gidrich sits in to this day.
Yes, sir.
And it's been 27 years since he's been there.
Yes, sir.
Now, interesting though, he's going to become chief judge in a month or so.
Yes, sir. Yes, sir.
So he's been sitting there, and we've been on the 19th, and the seats have remained that way, and the allocation has remained that way for the past 30 years.
So, even though you said the 1980 census, there was a census in 90, there was a census in 2000, there was a census in 2010, and now there's been a census in 2020. So there have been 4 census done since then, but there's been no change in the allocation of seats as the black population in East Baton Rouge Parish has grown.
Exactly.
And what is the legal justification for that?
The legal justification is that the state says, I don't have to change that because judges are not technically representatives. So there's no constitutional law, the way it sits now, that we can force. In other words, like the census that we do now for the school board,
Right.
for the representatives, that's a required reapportionment or readjustment every 10 years.
Right.
Judicial officers are not under that constitutional rule. So we have to go to the legislature and basically ask permission to adjust the lines. And that's challenging when your representatives from your parish say to you, no. Majority will not rule. Blacks became the majority in East Baton Rouge Parish, codified in the 2020 census.
Yes.
But it actually happened before that.
Yes.
But we didn't have a number count.
Right.
So twice I approached the legislature and asked for an adjustment to reflect the map on the ground. And despite that, we were told no, we're not going to adjust. Even though you're the majority, this structural mark in the sand will still maintain an imbalance of 3-1, even though you are the majority.
Now, again, I don't want to be repetitive. What's the justification for that? I mean, you and I both know that it's wrong.
Yeah, okay.
I'm trying to understand what excuse is used in order to make the decision that they make.
Power.
It's just that simple.
Simple as that.
Yeah.
Power.
Yeah.
And when your appetite is such that you're accustomed, then it's difficult to share, and particularly share where you are either become a minority in the arrangement or you are an equally balanced arrangement. So it's challenging, and I've been trying to not act out with anger. I've been trying to be reasoned with it, but here's what it amounts to, Reverend. It makes me feel as if I'm 3/5 of an individual because I'm the majority, but yet I have to accept minority status, and that's wrong. And I've explained that that's wrong, but so I decided not to just explain it and just sit with it, and I decided to run.
Well, what you're doing is really monumental when you put it in the context, and that's why I wanted you to share the context of it. When I heard you share that story the other day, it changed my thinking about this whole thing, because what you're doing is really, really powerful stuff. You are running in a district that was designed for you to lose.
Yes.
And yet, in the primary, you finished first.
Yes.
So that speaks volumes for what people think about you and your years on the 19th Judicial District Court and what you bring to this table. How do you feel about your election going forward? You're in a runoff. I think you finished with 46% of the vote.
42.
You finished very close to what you needed the first time around. What do you think the prospects are this second time around?
I think it's all mostly turnout, but here's what I said in a paper the other day. There's a perception that you cannot win. There's a belief system that your color in a majority system matters, and it does. Let's recognize it has a factor. But I have told myself, this is what was so unique about running in this race. Dr. King said it best. Before he could lead us, he had to get the slave out himself. I don't even remember him saying.
I do.
All right, so
yes.
I had to get that mentality out of myself that somehow I could not run in the majority district. Because everybody, we tend not to want to do that.
Right.
So I had to resist that temptation. So first, I had to internalize something in me that it was nothing negative about my color. It was not going to be a negative factor. I was going to make it a positive factor.
Yes, sir.
So that first I had to do something to me. Then I had to let other people believe that it doesn't matter to them. And without leading with that vision, we stay where we are.
Yes, sir.
And our children, this is what we're teaching them. No, you stay up. That's not for you. No, you can't run here. Because they don't see us thinking ourselves outside of our zones. And that is something I've come to realize now. That's a defeatist kind of attitude.
Yes.
It's a limitation. We limit ourselves with that.
And I appreciate the thinking that you have put into this. I appreciate the bravery, really, that you have shown in running. But it shouldn't be like this. I have been thoroughly frustrated with this whole reapportionment process. Okay. I watched what they did with the school board reapportionment.
Okay.
When I say I watched it, I wasn't watching on television. I was in the room when they did that. Right. And it was bully politics 101. We came in, they gave the public the opportunity to speak. We spoke for 3 or 4 hours. Some people spoke more than one time. And when they closed down the public speaking, there was a motion and a second, and they kept the lines the way that they wanted them to go. And then they went on about their business. The same thing happened at the Metro Council. So I watched that failure of reapportionment. The governor refused to veto the state legislature with regard to congressional seats and with regard to state legislative seats. So we have lost, to my way of thinking, 4 times in this reapportionment season around the 2020 census. And it is frustrating as a black man to be told on the one hand to encourage people to go out and vote, and I am a voter.
All right.
I vote for anything and everything. If it's dog catcher, I'm going to vote. But to be told go out and vote and your vote matters when in fact my vote has been diluted through unfair reapportionment practices.
Yeah. Exactly.
So, what's your response?
My response is you constantly demand to be treated as an equal. If you don't, you innately accept that you're not a man. You're partial. And we speak truth to power. And if you don't do that, then the opposition never knows that you know what they're doing. You've got to tell them. And you've got to look them in the eye and say it. You know, that's what I did. I looked them in the eye and said, this is not right. And when you fail to do what's right, you traumatize and you harm. And that harm has to be remedied. It has to be dealt with. So the longer you keep it the way it is, the longer you extend the harm. And what I guess, and I've been asking myself, what is so frightening? What is so so concerning about the fact of black leadership or black elected officials that somehow we're feared? And I don't know if it's the fear of a factor of us thinking that we're going to do unto them as been done.
As has been done to us, yes.
And we're not.
No.
That is not the nature of the people that we are.
No.
But that's the only thing I can see. Why is this desire for power? But I wrestle with it because we're judges. That's a distinct difference. I'm not a politician. I don't sit there and deal with policies of politicians. I sit and deal with justice. And being a judge, you got to deal with the facts. And you want justice to come from what you're dealing with. So it's difficult when you're challenging judges and you're challenging them to ask them. So what I'm empowered to do is go to my judiciary and say, you should change this. If the legislature is going, you recognize that they're wrong, then you need to speak up and say, judiciary will not accept this. This is just not right. And that's something that I think our Supreme Court should step up and tell our legislature. You should redraw these lines. We're judges. We're not, this is something, that's the very reason why this rule of equal representation has not been placed upon us, because we don't play that kind of political avenues of how to get elected. We're tied in our tongues on what we could say in the public about our opponent. We have limitation on what we could say on the radio, on the television, on the commercials. We have a code of canon. We have a canon. Just like in your faith, you have a canonical canon that you live by.
Sure.
We have that too. So it's been, and I'm not sure if I answered your question though. I may have tailed off here. So if I'm not directly answering,
no, you're doing fine.
Okay.
You're doing fine.
Okay.
Help our audience and me to understand why there are so many different levels of courts.
Okay.
You have juvenile courts. You have family courts.
Right.
You have city courts.
All right.
You have district courts. You're currently running for the Court of Appeal, and then you have the state Supreme Court. Help us to understand what all of these different levels of courts mean.
All right. So the American system was set up where a federal system, before the federal system was created, we only had states. If you remember, we didn't have a United States of America. We didn't have a federal government. We only had 13 states. And those 13 states decided, and they had their own state systems, courts. They had a Supreme Court, and they had, sometimes they didn't have an intermediary court of appeal. They had a trial court, Supreme Court. But over time, the work was such that they felt that they should organize it. So it was an organizing way of doing business. You would have the trial courts to hear the facts. And then if that trial court had made errors, either party could go to a reviewing court, a reviewing body, and that reviewing body of judges would review the work that was done below and fix or correct mistakes or errors. So that's generally it's the Court of Appeal or Supreme Court above the Court of Appeal. So most of our states have organized justice in that framework. A trial court will hear both sides of the issue. If it's a criminal case, they'll hear the plaintiff, they'll hear the state witnesses and the defense witnesses, and then a decision is made. Same thing in the civil matter. So that's the way it generally got organized on state level. And then when we created the United States from those 13 states, we developed a federal system that mimicked the state system, trial level, middle level. So now you have a federal court system. We have the United States Court over on Florida Boulevard. It has a trial court. It has a trial judge. So we have two different structures, two different systems. But to get back to your answer about the types of courts in Baton Rouge, over time, the various courts in Louisiana came about because more and more litigation and more populations. So right now we have about 33 district courts in Louisiana. This, where we sit, is in the 19th judicial district. So if you took the boot, you'd see about 33 district level courts. And then above that level of 33 district courts, you have 5 courts of appeal. And those courts of appeals sits over the whole state, and they have regions. And the Court of Appeal for Baton Rouge is called the First Circuit. And in the First Circuit, there are 16 parishes. So you have the Second Circuit, they have about 16 or 18 parishes. Third have a number of parishes. So that's the way the Court of Appeal is divided. Then on top of the Court of Appeals in Louisiana, you have a Supreme Court. And it's 7 justices, they call them, that sits there.
Right.
And they are elected from regions throughout the state of Louisiana.
Okay.
And right now, we've only had one in the history of our state, that one black that was elected, and that's from the Orleans area. So we have one black sits on the court with that 7. And in our area where we are, we have what's called an associate justice who is over our region. And cases go to him, but then he sets them onto the full court. Now, in East Baton Rouge, we have the following courts. We have the State District Court where I am, and we have other district courts. We have the Family District Court. We also have the Juvenile District Court.
Right.
Now, we did it that way because of the work. And now every court is different and throughout the state. For example, we go across the river, which you're familiar with. The judge over there on the 18th Judicial District, their jurisdiction has all of these types under one judge. Juvenile, family, and what I do, civil and criminal. One judge has, it's more than one judge over there, but that judge has authority over all of that type of subject matter.
Okay.
Because of the way it was created, when it was created. Baton Rouge, we decided to divide ours up, so we have specialized district courts, juvenile, family, and district. And then, now those are state courts. All right. Then we have municipal courts. Municipal courts are not created by state legislative law, the legislature. They are created by municipalities to deal with minor matters, misdemeanors, and cases that are not beyond $25,000 or $50,000. So those cases go there to the municipal court. And the municipal courts are determined by the city government. For example, our city court of Baton Rouge. We have 5 city court judges.
Right.
They're elected from the city of Baton Rouge, not from the parish.
Not from the parish.
Right.
So the Metro Council has nothing to do with apportioning city court levels.
Actually, they do.
Okay.
But the Metropolitan Council, if you remember, is both
It's a consolidated government.
There you go.
Yeah. Yeah. And so they handle both city matters and parish matters.
That is correct.
Okay.
Thanks a lot.
Well, it's a convoluted system,
Yeah.
and that's not to say that it doesn't work, but for those who are not lawyers, I'm one. My sister tells me all the time, you don't know anything. I have plenty of opinions. She says most of them are wrong. But I'm just curious as to how that whole thing got set up. So the Court of Appeals, which is the office that you are seeking, is a review court.
Yes.
Over over the work that's being done by the lower courts.
Yes.
And so you deal more with matters of law, not matters of evidence. Is that correct?
Actually, we deal with both at the trial level.
Okay.
Because we decide the facts.
Okay.
Okay. Principally, we're a fact-finding body. Now, we have to, when we find the facts, we then apply the law to those facts.
Okay.
At one time, and I understand what you were saying, the appellate courts did not deal with both issues. They let us decide the facts, and they decided we made a legal error.
Right.
But now with the changes, they review both fact and law.
Okay.
That changed over time, but yes, initially that was the way it was.
Okay.
But it's changed now. It's changed considerably. So they can review our factual decisions, but it's not the type of review that they just can automatically change. It has to be a serious error, not just any error. No evidence, and you found someone guilty, but that was no evidence. They will correct that. But if it was debatable, then they're not going. Our discretion governs, and we have discretion with certain issues that come before us.
Now, the gentleman that you are in the runoff with, Hunter Green.
Yes.
He too has judicial experience or none?
He has 7 years on the family court.
Okay. Okay.
7 years on the family court. Which
Whereas you have 29 years
Yes.
on the 19th Judicial District Court.
I have a combined 29 years of judicial service. I served also, before I got to be a district judge, I served on city court. I think I may have been the fourth black judge to serve on city court. And I was over there for about 6.5 years, almost 7. And then I ran for the district court, where I've been for the past 23 years.
Okay.
So the combined is 29 years. This is my 30th year, starting next month.
I understand.
So it's a long time.
So you said earlier that you're bound by a canon of ethics
Yes.
that precludes you from saying certain things about your opponent. And you've also said that you're not political.
Yes.
So if you're not political, and if you are bound by a canon that says you cannot attack your opponent, what's the basis of your campaign thrust?
My campaign thrust has been about, well, several areas. Number one, when there was no black on the court at all in this parish, I remember Judge Rosemary Pillow asked us, because we were complaining about it, well, when you all get a qualified black, we'll vote for him. That was the statement I heard in the meeting. And I said, well, qualified, what does that mean? What does that mean? We all had licenses.
It's one of the most patronizing, insulting statements you could ever possibly make.
When you're sitting across the table and you're trying to get an agreement, you hear that kind of thing, and you say, well, innately, that's what I've been fighting against all my life. Innately, I accepted that maybe I wasn't. So I ran real fast and caught up, though. That's why I have the qualifications. Here's what I decided to do. I went to law school, LSU, got a law degree. I didn't stop there. I said, well, maybe that's not good enough. So I went and got 3 master's degrees. So maybe that's not good enough. And I went and got 2 PhD degrees. And this was not over online. This is sitting there hours and hours and writing.
Yes, sir.
But you know what, Reb, I don't know. I asked myself, am I qualified now? Am I qualified? Because this unique idea about yourself from grade school, growing up, I wasn't feeling I was equal. I didn't believe it. I told people I was, but did I really believe it inside? And I don't know. I remember this, and I don't know if this is the way I should put it, but first grade school, Miss Scott at Park Elementary, she came in class and she said, students, you all are behind. And my brother and I sitting there, and we behind. It's the first day of class, first grade. So we got home, and my mom was a maid. She came home, and she saw me and Ron looking up to her, and I guess we had water in our eyes. Mom, we're complaining. Why are we behind? And she looked over at us. This was an amazing woman. She looked over and she said, she didn't want to mislead us. One thing about my mom, she would tell you the truth, right?
Yes, sir.
So she said, yeah, you are behind, but you didn't put yourself behind. Now run real fast and catch up.
Benjamin Mays.
I don't know.
Did he say that? He who runs the race, he who starts the race behind must run faster than the rest, or else forever remain behind. It's one of my favorite quotes. My father used to say it all the time, and it's been ingrained in me. But I listened to your niece the other day, Judge Ebony Johnson Rose. Judge Ebony Johnson Rose. Judge Ron Johnson. Judge Don Johnson. Judge Ebony Johnson Rose. Just making a point. I heard her and you debating about how many degrees you actually had, because you said it was 6 and she said, no, you miscounted. It's actually 7. So I was listening to you go through the degrees that you mentioned, and I think I came up with 7 just listening to you talk. So I think you're qualified.
I think I'm qualified.
I think you're qualified. Yeah. So the runoffs generally don't draw the same amount of attention that primaries have. There are certain other things on the ballot that might help with with turnout. There are 3 constitutional amendments that are on the
Yes.
ballot. There's some public service commission elections that are on the ballot along with your judgeship. What exactly are you doing, is your campaign doing to help generate turnout for this runoff election?
And I had thought, I had assumed that a large segment of the community was connected to the election, which was somewhat, I guess, not accurate. So, because if the turnout had been greater, I wouldn't be in a runoff.
No, you would have won.
I would have won. So there's something that's disconnecting with the call or the clearness of what message we have to deliver to get people who did not have the right to vote not long ago to renew that belief in their power of their vote. So I asked myself, so how do we get this message out? And I remember listening to a speaker, and I can't think his name, but he concluded this: it's almost sinful. It's almost sinful not to vote for a people of ours because of what we went through, because what our elders struggled to fight to give us.
Certainly.
And to abandon that, or to not to understand the power in that. So I asked myself, how do we reconnect? So you asked me, well, how do I reconnect with our people? Tell the truth. I think that if we tell them, you have power and you're not using it, you need to renew your strength and renew your power so you can determine your fate. So you can determine what you want in your community. So you can determine what streets are fixed. So you can determine what laws are enforced to the degree that they're enforced. I believe that with so much apathy, or with so much disconnect, and our attention's being diverted, that we've lost the central idea of our own empowerment. So preach the gospel, and you gotta tell them. You gotta tell them. We gotta plant the seeds and let them grow and nurture them. And I think that's the way we renew it. So my campaign is about getting around to everybody. Everybody who has been abandoned, or who feels they've been left behind, who's not warmly received, who's just lost. And I'm going to them. I'm going to talk to them. I'm going to tell them, look, give me a chance. Let me serve. And I think it's important that we do it directly, and that we show them that we are capable of leaders and we can do it. And if they believe in us, if they see us working and see us carrying out the job that we're supposed to do, I believe that the shift will occur. On this campaign trail, I'm running across people I hadn't seen in 40 years. And I'm reminded of what I was doing at the time. I'm reminded of the connections that we had. I'm reminded of the streets we couldn't cross because of the way we looked. We dare not go. And they remind me of this. Don, you have an obligation to go and change it. And so that's what I'm asking my parish to do. Let's go change it. And I'm counting on you. I'm counting on you to carry, so that when I go, then others can follow. Somebody has to go, and we have to go. And I think that if I just tell them the truth and tell them to help me, that I believe that they'll come. They'll come. So that's what I'm hoping.
You've been in judicial seats, as you said, for 29 years. Can you share with us what has been the greatest improvement over those 29 years? You came in and you found this, and 29 years later, it's this. What has been the greatest shift?
Well, the greatest shift I saw was the people that followed. When I arrived at the city court many years ago, there were almost no staffs that looked like minorities. We had a few judges on city court. I was one of two and I was there by myself at one time after Judge Tyson left, and after Judge Calloway left, and Judge T.H.R.I.V.E left. But there were insignificant or a very small number of staffs that were minorities. So my idea was to help with that. That was one of the things that I was I was going to demand, and I was going to ask for. So as I can look over 29 years and see the total composition of the makeup of the court staff. And that was very important to me because I wanted to make sure that opportunities existed for people to get jobs and work. So that was one level of change I saw. But the other level of change I saw was the transformation in our peers. Whereas there was a perception that we were not up to the job, or we couldn't do the law, or somehow our knowledge skill set was lower than others. We changed that very quickly. So the perception now has changed. There's an acknowledgement or acceptance that you are capable and you know the work and you can do the work. That's been another major shift in that. It's not all 100%, but largely it's there. And the other thing I see that's important is that we bring a perspective to the law of what justice is. We bring a perspective that you apply law to the facts, but when you're sentencing, there are issues that you must recognize are bearing on the outcome of the person you're sentencing. So the one thing that I can say that I know now is the individual standing before the court in the criminal court is we're looking at underlying causes. And this is why I have been innovative in the direction of moving the court. I'm the recovery court judge. That was the drug court. Well, what is that? Well, it's a treatment kind of approach. Rather than just convicting someone and sending them off to probation and letting them figure it out, knowing that the success rate is much lower if you just pass the ball to them and say, okay, stay out of trouble. No, you got to help them stay out of trouble. You've got to want to see them succeed, and you've got to invest the court in that success. So that's the new model. It's called, some call it therapeutic jurisprudence or problem-solving courts, and I've invested a lot of time in that. So we have now the development of the last two models, 4 or 5 specialty courts at the 19th, and I'll go over what they are. I sit on the drug court. That now you accept responsibility that you're an addict, you're committing crimes. Your crimes are related to your addiction. So rather than just put you on probation, we're going to put you on probation with treatment, and we're going to help fund the treatment. So your recovery chance of getting away from the chemical is largely elevated, and you succeed. So that's the drug court, treatment and probation. All right, recovery court. Then I also started up what's called a pretrial recovery court. The drug court that we have, you have to plead guilty to the crime, and then if you complete the probation, the conviction can be set aside. But this other court I started is a pre-plea court. You don't plead at all to the crime. You just go directly into treatment and supervision. If you complete that, the district attorney never files a charge against you. That's the pretrial recovery court. So pretrial and then the recovery.
Now, does the district attorney have to assent to that? Does he have to give approval to that?
Yes.
Okay.
Yes. And it's constitutionally based because his office under the Constitution has the absolute right and authority to decide what case to prosecute and what case not to prosecute.
That's what I thought. That's why I was wondering about that.
But it's a collaborative thing.
Okay.
See, now whereas we were sitting across the table as an adversarial and the judge was in the middle, you the prosecutor, here's the defense attorney, and you all going at it adversarial. This model says if your client wants to get help, we will sit down as a team.
And decide on the best way to administer that help.
Exactly.
Okay.
It's a collaborative approach. It's not an adversarial approach.
Gotcha.
All right, so that's the model for the treatment court. So now we're bringing forth we have a reentry court. Well, what is that? That's where an individual has been sentenced 7 years and he's got to go to prison, or 10 years he's got to go to prison. That's what the judges sentenced him to. There's an option for certain types of crimes that says this: if you agree to go into reentry court, we will assign a judge for you. And rather than serving that 7-year sentence or 10-year sentence at Angola or Hunch or Dixon, we will send you to that facility, that correctional facility. On that campus of the prison, you'll be assigned a dormitory. In that dormitory are only people that are sent into that institution who intend to come out in 2 years. And while you're housed there, you go to school every day. While you're housed there, you're going to get a skill set. When you come back, you will be able to walk out of prison into a job. It's all designed. The old model, Rev, was you came out of prison and everybody just welcomed you back. You went on, you try to find a job, go get your license. This model is not that way.
I understand.
This is planned success, planned to re-enter our community. That's that model. So we have the reentry court, and one judge oversees them after they come back out, and they go into court once a month and be reviewed and keep up with their assignments. All right, 2 other types of courts are coming this year. The Veterans Treatment Court for our veterans, and that will be specifically for them who are in crime because of PTSD or issues related to substances. A lot of our veterans are alcoholics or they're using substances. So it's a recovery court, but specialized for veterans. And then we just got approval to do what's called a domestic violence court. And that is one that I worked very hard on. Here's why. A lot of us are in love, and we challenge with our relation. When we get into an argument, it leads to violence. It leads to contact. And that contact is going to result in one of us being arrested or getting convicted. And then if you're in love, more than half the time you're back together within the same week. So this trend is cycling through the courts.
Right.
So we designed a model that says this. If you're going to stay together, but you're at each other all the time, then why don't we give you some support and some treatment with respect to how to avoid that, how to resolve that difference of opinion. If it's money, if you got alcohol involved, you got drugs involved, how are we going to help this family? Because they're in love, but they just fight all the time. So we got to deal with that intentionally. You got to go to them. So that's the domestic violence court. And it's designed to counsel, and both parties come in. Unlike the old system where if you're the perpetrator of the domestic violence, you got convicted and then you got sent to probation. Well, this model says if you're going to stay together, both of you need to come in.
I understand.
Same thing you do here to keep us together.
Yeah.
You can't just treat me if I'm the married one. And you got to have us both here.
Yeah.
So that's that model that we put forth.
Can I ask you a question
Sure.
about funding for criminal courts?
Okay.
Not so much having to do with your campaign, but you're a judge, so I'm sure you see this. Prosecutors are far better funded than public defenders.
Yeah.
When Mr. Mitchell was the chief public defender, he regularly complained that his office was overwhelmed with cases and severely underfunded. I glance at the parish budget from time to time, and the district attorney's office is handsomely funded as opposed to the public defender's office. Plus, the district attorney has programs that they implement at a cost, most of the money going to the DA's office to supplement what they don't get out of the budget.
Yes.
I know that Miranda says you have the right to an attorney, and if you cannot afford one will be provided for you. But if the attorney that's being provided has 300 other cases and no money with which to offer a proper defense, how can that be deemed fair?
Fair. Well, yes. As a judge, I sit and I say, and I've had cases that come before me which have challenged the funding arrangement. Under the line of jurisprudence that our Supreme Court has set for us, if I appoint a case or assign a case to a public defender, the public defender now has to say to me, Judge Johnson, do you know how many cases I have? I cannot have any more, and we'd have to hold a hearing. I agree that there's an imbalance in funding. What we've been trying to do with this is have both sides equally funded so that the staff will be equitable, equally supported on funding. The lawyers would be. It's necessary. It's necessary. Otherwise, you create a structural imbalance in the ability and the capability of the defense team. And it's plaguing us right now. I'm certain that the Public Defender's Office will continue to push to try to get fair funding, but I cannot remedy that. From the law will not allow me to just directly say, I order the parish to provide funding for the public defender. Mm-hmm. I'm restricted from going into the parish's budget and taking the money and say, no, you're going to allocate X. That's been tried and litigated, and we don't have that authority. So I can't do it.
So, but does it not prohibit you from doing your job as a judge?
It does.
If you can see clearly, prosecutor over here has almost everything at his disposal to put forth an adequate prosecution, but the public defender has nothing at their disposal in order to provide an adequate defense.
I get exactly what you're saying. And the public defender has to say to me, Judge Johnson, I don't have funding for an investigator. I don't have funding to get this analysis done. I don't have funding to send someone to go and talk to this witness. So I need delay. I need time, and that's the general approach to it, to give you more time to develop and to defend yourself. Now, that may work against you if your client's in jail, because your client is sitting there.
Right.
If your client's out, then it may work to your advantage because you don't really want to come in and try it anyway. So the idea is to try to balance it out. I just hope, I just hope that our legislature would finally step up to the plate and quit talking about not funding adequately the public defender. And my perception is this, and I'd like to be very, very candid with you. We campaign on being tough. That's the model, all right? All right. We feel somehow safe.
That's it.
All right. So if you're campaigning as a DA, I'm tough on crime, you get funding from the executive office. But a public defender is not campaigning with that model of toughness. I've asked us to start talking about the new framework for tomorrow. That new framework is strong and smart. We must be strong, but we must be smart with our strength. I can be tough any day of the week. When you have a hammer, you're not required to use it. It's only the reluctance in using the hammer to get someone to change. You should start with your toolbox full of tools. And if you're not a fair jurist, you don't reach for the hammer. That shouldn't be automatic. That should be your last tool to hammer someone. So I want to fill the toolbox up with an assortment of tools and find out which one works the best. And in that, it takes experience, but it also takes courage, because you have to defend against yourself, especially if people are saying you're soft on crime, because a lot of our politicians, that is a label that they run from, and they run from that.
I hear what you're saying, and I've heard that argument before, and I'm absolutely certain that you are right in what you're saying. But if our conservative brothers and sisters, because it's conservatives that don't want to give public defenders any money. Let's be clear about that.
Right.
Ain't no liberal, ain't no progressive saying don't give public defenders any money. It's conservatives who feel that way.
Right.
If conservatives believe in the Constitution of this state and of this nation, then constitutionally, they should want the courts to be as balanced as possible. And balance implies proper funding to both sides.
I agree. So you wrestle with this. You're wrestling with this. You say, well, do you believe in the Constitution only when it favors you?
Yes.
That's right. That's only when you're the majority do you believe in law and order.
Yeah.
Now that I'm the majority, do you want law and order from me? I don't know. So it's complicated, but it has to change, and if we don't try and talk about it, which is what we're doing today, if we shy away from it and don't want to tell the public exactly what the deal is, then I don't feel as if I'm doing my job, and I wouldn't want you to vote for me if you feel that somehow I'm going to sit around a table and compromise your liberty or compromise your freedom. No. I'm going to go in and speak up. Now, I may get voted out, but I'm going to say something because I have to. I have to say it for myself, too. I have to say it for myself. But I do get what you're saying, Reb, and I believe we have work to do.
Are there too many lawyers in Louisiana?
No. It's a lot. It's a lot.
There are a lot of lawyers in Louisiana.
Yeah, it's a lot of lawyers.
And sometimes I hear that this state is over litigious.
Yes.
And that there are too many lawyers in Louisiana.
Okay.
Your opinion is that
I don't think so. And here's why I say that. We have 4 law schools in our state. And it's been that way for a long, long time. It was that way when I started out as a lawyer. 2 in New Orleans, 2 in Baton Rouge. There's only one minority law school in this state, and that's Southern University.
Southern University.
There's only one. So we have Baton Rouge has, and we have 3 other campuses. Now, the good thing is you can go anywhere you want. You're not limited about which school you can go to, but I think that the mission of the schools are important, because each school does have a different mission of what they're there for. I'll share this with you. One day I attended LSU Law School. My twin attended Southern Law School.
Yes, sir.
All right. So we're talking about it. And what's the mission of Southern Law Center? What's the mission of LSU Law Center? LSU says, well, basically at the time I read it, said something like, we want to make the best lawyers in the state. And Southern says, we want to make lawyers to go out and do justice. With a purpose of justice. So it's a whole different approach to what the lawyer was getting licensed for. So you've got these groups of different missions out here on different agendas. And it's necessary so that you'll have a composite of jurisprudence and lawyers out here. So I don't think the number is high. I don't think it's too much. I think that with the different missions that the schools have, or the students that come from those schools, the ones that take that mission and go out and work hard and try to make law work for people, make it work for people, not just work for politically connected, powerful money interests. And so I think we need lawyers to come from different perspectives.
Early voting begins on
this Saturday.
As this is being seen, which will be Monday, the 28th. So early voting will have started by the time this is seen, and it runs until December 3rd.
December the 3rd.
December 3rd. Any final thing you want to say to the voters as we close?
I want to say to us as a people, renew our faith. Let's get back to where we were. Let's get back to believing in our power and our ability. Let's get back to doing what we know we need to do as a people. Let's carry forth the legacy of our elders. Let's go vote. And when we go vote, we will see a change in the realness of what we're about, and we will quit being so apathetic because the outcomes will be different. Send the people to those duties and responsibilities that understand where you are and what you need to do. So I ask you to vote. If you don't vote for me, just go vote for somebody.
Yes, sir.
And it's the perception is ended that you don't vote. You don't matter because you don't vote. And you talk about Black Lives Matter. You talk about you do not matter if you don't vote. You don't matter. So that's what I'd like to leave everybody with.
First Circuit Court of Appeal candidate.
Yes.
Current 19th Judicial District Chief Judge.
Oh, yes.
Don Johnson. Thank you so much for taking the time to come and share with us on the Thrive Podcast. Thank you all for viewing. Thank you all for listening. We'll be back again next time.